Township Council for Monday, March 26, 2018. Adequate notice of this meeting has been provided to the public and the press on January 5, 2018, and was posted on the bulletin board in the municipal building in accordance with the Open Public Meetings Act, NJSA 10:4-7.
Roll call.
Councilmember Ooms.
Here.
Councilmember Kadish.
Here.
Councilmember Van Tassel.
Here.
Councilmember Allberger.
Here.
Council President Murphy.
Here. Please rise to salute the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This evening with us we have the court administrator, Donna Zedema. I said it better earlier. If you could please come forward, and Donna has some presentations to make. We have with us the Community Dispute Resolution for Volunteers. Donna has with her Carol King, John Hackett, and Lynn, is it Negley? Negley.
I first want to thank the council, the mayor.
Donna, sorry.
I want to start off by thanking the council, the mayor, and the business administrator for giving me this opportunity to honor some of our volunteers. They've served many years. I work for the court, and these three people that are being honored tonight have worked for what we call the Community Dispute Resolution Committee for many years. And unfortunately, Judge Devine could not be here tonight. He wanted to personally present these, but he has court in Franklin tonight, so he couldn't be here. So you have me tonight. So I just want to read a letter that Judge Devine has given to present to all three of the mediators. We have with us Ms. Carol King, Mr. John Hackett, and Ms. Lynn Negley. Should I have them come up?
Sure. Excuse me?
Should I have them come forward?
Oh, yes.
Okay. If you would come forward. I'd like to read this letter from the judge. Okay. Dear Ms. King, Mr. Hackett, and Ms. Negley, it is my understanding that you are receiving awards tonight from the Vernon Township Council. I am sorry that I'm not able to attend tonight as I have court in another municipality. You have each volunteered your time for many, many years as members of the Community Dispute Resolution Committee. In that, I am the judge of the Vernon Township Court. I am familiar with your efforts and the benefit the community receives from your hard work. You meet with the plaintiff and the defendant involved in a community dispute that has risen to a municipal court complaint. You listen to the parties, discuss their issues, and suggest solutions. Your suggested solutions are not guided by any court rule. Your solutions vary from case to case. The process involves you as a volunteer and the parties who are members of the community. The cases vary in nature, from barking dogs to trespass to loud noise to fence disputes and many other types of disputes. Your goal is to come up with an agreement between the parties, and your suggested solutions resolve the vast majority of the cases. If the case is resolved, it is dismissed, and that takes it off of the court calendar, thereby saving much court time, which in turn helps to reduce the budget. I would like to take this opportunity to thank you for your long hours and your years of service to the Vernon Township Municipal Court and your community. It is people like you who make the Vernon Township a great place to live and work. And thank you again, and that's from Judge James Devine. Okay. We also want to present proclamations to each one, and we did personalize them a bit, so I would like to read them about each person. So I'd like to start with Carol. Carol King. She's been a good friend of mine for many years since she started this mediation program. We started it. It's been in existence since 1997, and Carol has been with it since the inception. So I'm going to read this proclamation. And this is presented by the town council to you on behalf of them for your dedication and your years of service. So, proclamation, Carol King. Whereas it is the township's continued pleasure and honor to recognize citizens in our community for their special actions and continuing service. And whereas there are many that step forward in dedication and commitment to provide service above oneself in the daily life of our community. And whereas the Community Dispute Resolution Committee was established in 1997 as a means to provide residents that have minor disputes resolved without having to go through the formal court system. And whereas Carol King is a trained mediator and the liaison of the program since its inception in 1997, serving 21 years. And whereas Carol, a resident since 1983, has a volunteering heart, serving on the Vernon Chamber of Commerce, Warwick Valley Kennel Club, Juvenile Conference Committee, Republican Organization, Vernon Day Committee, Earth Fest Committee, State Insurance Committee for Continuing Education, and the Sussex County Disabilities Council, along with visits to nursing homes with her therapy dog, working on Rotary projects, and hosting church Bible studies. And whereas Carol holds a BA in zoology with 9 years experience in industrial pharmacology, international and domestic cosmetic marketing, and product development, along with 2 years employment for disabled people, along with her 36 years as an insurance broker and agent. And she's also fluent both Spanish and French. And now therefore, the council and the mayor of the Township of Vernon, on behalf of all citizens in our community, take this opportunity to recognize and honor Carol King for her continued service and dedication to the residents of the Township of Vernon and the Community Dispute Resolution Committee. We all thank Carol for giving of her time, talent, and experience to our community. Given under my hand in these free United States in the Township of Vernon, State of New Jersey, on the 26th day of March, 2018, and to which I have caused the seal of the Township of Vernon to be affixed and have made this proclamation public, signed by Mayor Harry Shortway and Council President Jean Murphy. So, thank you very much. Lynn, you're next. This is Lynn Nagley, who I've also known for many years through this program. This is her proclamation. Lynn Nagley. Whereas it is the Township's continued pleasure and honor to recognize citizens for their special actions and continuing service in our community, and whereas there are many that step forward in dedication and commitment to provide service above oneself in the daily life of our community, and whereas the Community Dispute Resolution Committee was established in 1997 as a means to provide residents that have minor disputes resolved without having to go through the formal court system, and whereas Lynn Nagley is a trained mediator of the program for 17 years, and whereas Lynn retired after 42 plus years as a registered nurse, has not slowed down, and is currently involved in the Franklin Borough Dispute Program, the Friends of the Library Sussex Wantage Branch, and the Friends of Wantage Animal Shelter. And whereas Lynn's past volunteering included 20 plus years working with disabled children at Camp Fatima's summer program, Citizens Opposed to Prisons and Parks, and the Board of Trustees for the Tri-State Actors Theater. And whereas Lynn enjoys membership in the American Ballet Theater, American Civil Liberties Union, Southern Poverty Law Center, and the League of Women Voters and Network. Now, therefore, the Council and Mayor of the Township of Vernon, on behalf of all citizens in our community, take this opportunity to recognize and honor Lynn Nagley for her continued service and dedication to the residents of the Township of Vernon and the Community Dispute Resolution Committee. We all thank Lynn for giving of her time, talent, and experience to our community. Given under my hand in these free United States in the Township of Vernon, State of New Jersey, on the 26th day of March, 2018, and to which I have caused the seal of the Township of Vernon to be affixed and have made this proclamation public, signed by Mayor Harry Shortway and Council President Jean Murphy. Thank you very much. This is for you, Lynn. Sorry. All right, and now a proclamation for John Hackett. I've also know John a bit through the mediation program. I'm very honored to be able to present this to you tonight. Whereas it is the Township's continued pleasure and honor to recognize citizens in our community for their special actions and continuing service. And whereas there are many that step forward in dedication and commitment to provide service above oneself in the daily life of our community, and whereas the Community Dispute Resolution Committee was established in 1997 as a means to provide residents that have minor disputes resolved without having to go through the formal court system, and whereas John Hackett is a trained mediator of the program for 17 years, prompting him to join the committee as a way to give back to the community. And whereas John, a resident since 1984, raising 5 children with his wife Eileen, and noting that one of his sons is a Vernon Township police officer, and whereas John, with his years of experience and expertise, working as the senior human resource manager at an engineering consulting firm in New York, and now as an independent human resource consultant, and whereas John holds a BS in communication arts, an MA in professional studies in human resources and management, and who is in the process of completing his MBA with a concentration in human resource management. And whereas John serves as chair of business outreach for the Engineering Expo Committee and vice president of the board of directors for Keep Rockland Beautiful, both of which are New York nonprofit organizations, along with holding a membership in the Society of Human Resources Management. Now, therefore, the council and mayor of the Township of Vernon, on behalf of all citizens in our community, take this opportunity to recognize and honor John Hackett for his continued service and dedication to the residents of the Township of Vernon and the Community Dispute Resolution Committee. We all thank John for giving of his time, talent, and experience to our community. Given under my hand in these free United States in the Township of Vernon, State of New Jersey, on the 26th day of March, 2018, and to which I have caused the seal of the Township of Vernon to be affixed and have made this proclamation public. Signed by Mayor Harry Shortway and Council President Gene Murphy. Thank you very much.
Thank you. Thank you. We have child abuse prevention proclamation. Would Councilmember Ohms please read that?
Sure. Whereas we all have a responsibility as individuals, neighbors, community members, and citizens of the Township of Vernon to help create healthy, nurturing, and safe experiences for children. And whereas healthy and safe childhoods help produce confident and successful adults. And whereas child abuse and neglect often occur when people find themselves in stressful situations without community resources and don't know how to cope. And whereas incidences of child abuse and neglect can be reduced by making sure all families have the support they need and deserve to raise their children in a healthy environment. And whereas it is recognized that no person can do everything, but that everybody or everyone can do something, and together we can create change for the better. And whereas effective prevention programs succeed because of partnerships among nonprofit organizations, government agencies, volunteer organizations, schools, services, clubs, house of worship, law enforcement agencies, and the business community. And now and therefore, the mayor and council of the Township of Vernon do hereby proclaim April 2018 as Child Abuse Prevention and Awareness Month in the Township of Vernon, and urge our citizens to engage in activities that strengthen families and communities to provide the optimal environment for children to learn, grow, and thrive, so that all children have the benefit of a happy, healthy, and safe childhood. Given under my hand in these free United States in the Township of Vernon on this 20th day of April 2018, and to which I have caused the seal of the Township of Vernon to be affixed and have made this proclamation public. Signed by Harry Shortway, Mayor, and Gene Murphy, Council President.
Thank you. Councilmember Kadish, would you please read the fair housing?
Proclamation. Whereas April 11th, 2018 marks the 50th anniversary of the passage of the Fair Housing Act, Title 8 of the Civil Rights Act of 1968 as amended, which enunciates a national policy of fair housing with regard to race, color, religion, sex, familial status, handicap, and national origin, and encourages fair housing opportunities for all. And whereas the Sussex County Association of Realtors is committed to highlighting the Fair Housing Act by continuing to address discrimination in our community, to support programs that will educate the public about the right to equal housing opportunities, and to plan partnership efforts with organizations to help assure everyone of their right to fair housing. And whereas the National Association of Realtors Code of Ethics commits all realtors to providing equal professional services without discrimination based on race, color, religion, sex, familial status, handicap, sexual orientation, gender identity, and national origin. Now, therefore, the Mayor and the Council of the Township of Vernon do hereby proclaim that April 2018, being Fair Housing Month, which begins a year-long commemoration of the Fair Housing Act in the Township of Vernon, and urge all citizens to wholeheartedly recognize this celebration throughout the year. Given under the Mayor's hand in these free United States in the Township of Vernon on this 20th day of April 2018, to which I have caused the seal of the Township of Vernon to be affixed and made this proclamation public. Mayor Harry J. Shortway and G. Murphy, Council President.
Thank you. Next, I'm going to move just something out of order here. On the advice of our township attorney, I'd like to make a motion to table Ordinance 1811. I'm making that motion. Is there anyone that has, can I have a second on that?
Second.
Roll call?
Councilmember Holmes?
Yes.
Councilmember Kadesh?
Yes?
Councilmember Van Tassel?
Yes.
Councilmember Olberg?
Yes.
Council President Murphy?
Yes.
Motion carries to table ordinance 1811.
Thank you. And next we have Mayor Shortway's presentation.
Thank you. Good evening, everyone. 2017 in review, moving Vernon forward. Vernon background, general numbers. A recreational community that relies on visitors to the area resorts. Our population is approximately 23,000, 68 square miles, natural resources, trails, farms, and beautiful open space. Some of the challenges: repair and maintain township assets. Basically, 2016 was a lot of assessment of what was going on here. The sewers, I had no idea. I knew we were paying the EDUs, but we were not hooked up to the sewers. We did not pay the connection fees, so we did. I found this out by looking outside my window and I see the septic tank is being emptied when I thought we were hooked up to the sewers. We weren't. And then the additional cost after the connection fees was actually hooking up to the sewer system. The roof needed to be fixed. I never saw anything like it before. When it rained, people were covering up their computers with plastic bags in the building. Outside my own office as well as inside my office, there would literally be just like rain coming out. So we undertook that project for $227,000. We repaired the roof. Fire suppression and water system. There is no fully charged water system, fire suppression system in this building. This will be hooked up in April, as well as it's all part of phase 2. The water pressure is so bad in this building that there's active water use on this end. You can't flush the toilets on this end. Fed by about 1.5 inch pipe from the DPW. That will be corrected in April when Suez hooks up phase 2. Challenges that continue: developers who ignore township resolutions, codes, and financial obligations. We also have the reserve for uncollected taxes, which, as you can see, is about $2.5 million. Legends is a major part of this, but it's throughout the township. That represents about 10% of our budget. Immediate challenges is the sewer debt. unpaid taxes and foreclosures, water phase 3, which we are actively discussing with Suez. As I previously mentioned, in April I will be meeting with the CEO of Vol of Suez. He's coming in from Paris. He's picking out different communities in the United States, and we're one of them. The Mountain Creek bankruptcy, the numerous vacant buildings in our community, and to increase the fund balance. The Mountain Creek bankruptcy. Mountain Creek did pay all its 2017 financial obligations. However, they have not paid any of their SOAR contractual obligations at this time. It was $591,581.25. That was due in January 31st. Another $187,000 plus was due March 1st. Additional contractual obligations, $211,812.50. That will be due beginning of July. Legends, another problem that's been here for decades. God bless you. There are a total of 156 liens on Legends, 103 municipal liens on the Legend properties. Redemption of these liens, $1,760,000 plus as of February 28th, and this is always fluid. The tenants, through the Superior Court, they will have to vacate by April 9th. The court decided to give each unit $1,500 to relocate. They haven't paid rent in over a year, and that's because they stopped collecting rents. So I think it was in November 2016, they were told they didn't have to pay rent. So, moving Vernon forward, foreclosing on approximately 125 properties with tax liens. Some of these liens originated as far back as 1996. We property taxpayers paid approximately $595,000 to the Board of Ed and the county as a result of delinquent tax bills in 2017. To stop the bleeding by foreclosing on these properties and auctioning them off, to put them back on the tax rolls so we can increase the value of the property. If you have a non-conforming lot next to your lot, perhaps you would want to buy it. That way you bring the value of your property and it's back on the tax rolls. So, April 18th, we are auctioning 95 surplus properties that the public no longer needs. Northwood. This is to the north end of Mountain Creek, the Appalachian, to the south of the White Elephant. They owe back taxes $169,000. Conforming fees are up about $588,000. The principal owner has been served with notices of violations. It took us almost a year to be able to serve them. Litigation, costly, but we have no control of most matters of litigation. The Mountain Creek bankruptcy, $64,000. Tax appeals, $60,000. We have over 400 appeals. Palladini versus Vernon is over $18,000. Litigation again, the previous Vernon Environmental Commission, over $7,000. There was a petition initiative review on that. That also cost us money. NWAC appealed its tax appeals. That was over $3,000. Lift stations to finally establish who owns the lift stations was almost $10,000. And the legends for the safety violations was over $7,000. The picture is an umbrella embedded in the ceiling on the 7th floor. It is over the toilet on the 7th floor because above it there's another toilet. When they flush that toilet, it runs down onto the people sitting there on the 7th floor. So that's one of the most horrendous conditions there. You see the ceiling's all torn apart. The yellow handle is the handle to the umbrella. The state finally came in and they cited them for 95 different violations. By far the majority are minor, but there were some serious violations there. Litigation. The court dismissed with prejudice the lawsuit brought forth by the former EC members. And this is in part, the decision is probably about 3 pages. The court concluded the plaintiffs failed to state any significant public interest other than the private interest in their positions as to why the 45-day deadline should be extended. So it was dismissed. Mid-American Salt was another lawsuit we had against us because we didn't buy enough salt from them. We just won that. I think that decision came down 2 weeks ago. The amended complaint does not contain any allegations that would support a finding of malice or bad faith. We operated properly, buying salt from different vendors who offered us a cheaper price. The court decision rendered regarding legends. Its essential government function is to protect the welfare of its people. Legends units are not zoned for permanent use because they are not designed for permanent use. And as a result of the conditions in the units, they are found to be unsanitary and unsafe. The township alleged that residents residing in Legends are contrary to zoning board resolutions 330-156 and fell under the prohibited use section of Vernon's municipal code. The court agreed with us. Municipal taxes. Municipal government's responsibility is to provide services in the most cost-effective means possible. Taxes. It is difficult to compare tax rates due to what services are provided and the county in which the municipality is located within. You never can compare apples to apples, because you might look for a similar municipality. Like I looked at West Milford and Jefferson, but both Jefferson's Morris County, West Milford's Passaic County. Outside influence on our taxes, the county solar panel fiasco, the county central dispatch system that Vernon receives no benefit, and I would argue that between Pacon, Newton, Hardiston, Vernon, and Sparta, we could do it all. Instead of budgeting over $1 million loss at the county 911 center. We have a county order revaluation. It's approximately $1 million. It'll be $200,000 a year for the next 5 years, including this year, to pay for it. The county demanded, this is relatively new, it started in September. The county demanded payment for programming for voting machines, contrary to state statute. Because of our population, the statute says we do not have to pay, so we're not going to pay. The real issue. It is expensive to reside in New Jersey. Consistently on top for the highest property taxes in the nation. Property taxes make up 40% of all state and local taxes in New Jersey. New Jersey relies on property taxes to fund local governments. New Jersey average property tax bill was $8,690 in 2017. Average 2007 property bill for Vernon is $5,657.01. Out of that, your 2018 municipal taxes on the average home will be $1,392. Tax dollars, where your tax dollars go? 58% goes to the Board of Ed, 19% goes to the county, 23% goes to the municipality, and which we provide services such as volunteers, DPW, the police department, this building, and all the employees that work in the municipality. We pay the lowest municipal taxes when compared to other Sussex County municipalities with police departments. Police departments are a huge expense. It's a big service, and I would not want to live in a municipality that did not have it. And ours does a great job. These are just some charts I put together comparing the different rates. And then you look at the budgets, the population, municipal miles. We also included there the qualified private community that we have to pay under the Kelly Act, and then your average assessments. So there's a lot to consider when you're looking at it. When you look at, we're paying $26.22, that was 2017, and you go across the board and you look at it. You see, as far as even municipal tax rates, we're the lowest. There, except for Sparta, but then you look at what their budget is, and then you look at their total average assessment, which is well over $300,000, $370,000. Again, this is a different look at the budgets, tax levies, and then the average residential tax impact. You can see it's right there before you that we're substantially lower than most municipalities. And Jefferson and West Milford are up there, but they're in different counties. So I had to look for what are some of the other municipalities that have police departments, and we can relatively say they're somewhat close. Here we looked at employees. We have 93 full-time, part-time 20, and we looked at the total personnel costs. Smaller municipalities, of course, Newton is over 8, and Hardiston's over $6 million. I would like to say Hardiston only has 6 DPW employees. And Sparta, they're a little bit higher than us. They have 112 full-time employees. Again, it's difficult to compare apples to apples because it doesn't exist. It's always going to be apples to oranges. So we looked at different aspects here. What we looked at, what we're trying to do is realign how we're doing with our employees. And although we're back up to 117, we're trying to lose an employee that's non-essential, or we could split it up into part-time. That way we're not paying the benefits. When we start putting the pension together, the family plan together, you're talking about $35,000 in benefits, which is considerable. If we can split that job into 2 part-time, and we like to get them working between 10 in the morning to 2, it's more apt to get someone that can do part-time and have children in the school. It also covers for all the lunches. And we are constantly reassessing that to be as efficient as we can. Not only efficient, but effective. Vernon, moving forward, personnel costs. You can see right there, this year, well, in 2017, we paid $586,000 less. Some of the big ways we did it, it was the overtime, $118,000. The police department has been outstanding at cutting back the overtime. And then with the health benefits, thanks to Chuck and Elka, we saved so much money this year going to the state plans. And with the unions, they were helping us in all for it too. There was a lot of work done, believe it or not, by the PBA, the police unions, looking at this for us. And they really helped us along to show the same. Redevelopment. The area need redevelopment study has been completed for the town center. This was voted on back in 2010, 2011, and never brought up. So we looked at it to try to use businesses coming in so we could offer things such as pilots. Suez has served and will serve letter for water to developers of proposed restricted living project plan for Omega and Theta Drives. This administration is actively engaged, as I said previously, for Phase 3 to bring water to Main Street. To move forward with the fund balance, we need to bring this up. The former administration began to excessively draw down the fund balance to stabilize the budget in its deal not to raise taxes. It decreased from 2013 to 2015 over $1 million. So, Moody's Investor Service Financial Report, which we got at least every 6 months, the available fund balance as a percent of our operating revenues is 19.2%. It's weaker than most U.S. median and decreased materially from 2013 to 2016. So, from 2016 on, we started making a plan to bring it up. And there you can see the numbers back in 2013 was clearly over $3 million. By 2017, we're back to $1,843,330. But you see the big difference where it was constantly losing. Now we're in black. $239,000. We only used $600,000 last year, opposed to over $1 million the 3 previous years. So there's what we increased it by this year, 2007. Okay, from Moody's again, the ability to generate balanced financial operations indicates good financial management. In this situation, Vernon Township approximately broke even, whereas the tax base generally decreased. The credit position for Vernon Township is a strong AA3. Notable credit factors include a positive socioeconomic profile with a healthy tax base and a satisfactory financial position. The credit profile also incorporates a manageable debt liability with a slightly elevated pension burden. Our goals: sustainable economic development within the Highlands plans that includes farmland preservation, agricultural and ecological management, needing to act like an eco-tourism. This is natural, it's here, it's nothing we have to build, we just have to maintain it and show it. Objectives: concentrate growth into the town center. That's where the sewers are located. We're pushing about 54,000 gallons per day. We have to get it up to 99,000. Provide housing for seniors who are age restricted. When this water is hooked up to here, they'll be able to hook up to the water and Omega and Theta. We want to promote our cultural resources and create a true four-season destination. We know it works because look at the AT. The police department, again, with the help of last year's council, it was great that we got the AT situation parking over there settled. Projects to increase revenue, attracting businesses. The last auction again, April 18th. Redevelopment. We also are looking for a redevelopment area study now where Legends is. We want to complete Phase 2, that should be done in April. Bus transportation survey. Congressman John Hunger's office has been crucial in this, trying to get USA coach to run a line directly from here to Manhattan. Surveys out. They'll assess the needs of that survey. They're looking for at least approximately 150 riders per day. And Legends Sewer Service. We'd like to get that in, get that redeveloped, hook up into the sewers, and then we'll be on our way to overcoming this gap. Highlands Regional Financial Feasibility Analysis. This was done with a grant. A town center requires creating a market. It simply means to provide a product that does not currently exist. We need a walkable, mixed-use town center. Town center plan in 1995, a mixed-use area with retail and pedestrian activity, residential, commercial, cultural, and recreational and entertainment uses. This is nothing new, what I've been proposing. It's been in the plan since 1995. Establish a town center with a commercial area, keeping the rural mountain character, a network of pedestrian and bicycle paths which link residential neighborhoods with open space, community facilities, and commercial areas. Move Vernon forward. The Board of Ed approved the sale of the former offices in the building near Black Creek Drive. Buildings were sold to commercial interests. This is another step towards creating a walkable, mixed-use town center and additional revenue into the budget. The economic impact of parks. Trails like good schools or low crime create an amenity that commands a higher price for nearby homes. We want the values of our homes to go up. Most of us, that is our major investment, is our homes. Municipalities throughout the United States have found economic benefits in bike trails within close proximity to residential areas. But we need to get these commercial areas developed in town centers, where the sewers are, where the water pipes are. The Suez has to upgrade their pumps to bring the water in, and we're going to need a water tower for fire suppression. The Greenway Initiative, we are designated as the best town in New Jersey for nature lovers by xfinity.com. Volunteers last year blazed approximately 2 miles of trails. We are an Appalachian Trail community. We kept that quiet because of the problems we had with the parking. April 28th or 29th, we will formally be recognized as an AT community. And the AT parking, as I said, has been rectified. We're still working on the 94 side, but that's going to be a state issue. Some of the grants we received, we paid that last year. We received a 2018 DOT award, $235,000 for Way Yarmouth Road. We also have money now to complete the repairs at Barry Lakes North. Responsibility. It is the obligation of this administration to formulate and propose solutions. Only then can we realize economic growth and tax stability. Progress is a choice. Vernon residents have been penalized by decades of political strife. Let's continue to go forward with due diligence and create opportunities for our community. Thank you.
Thank you. Okay, we'll be moving on to public comments. Please note that the comments are limited to 3 minutes per person for agenda items only. May I have a motion to open the floor to public comment?
Motion.
May I have a second?
Second.
All in favor?
Aye.
Any opposed? Is there anyone from the public that would like to step up and make a comment?
Hello, my name is David Lally. I live in the Sussex section of Vernon. I want to make a comment about the soil ordinance you're talking about enacting. In the community I live in, there's a gentleman who's been dumping continually hundreds, if not thousands, truckloads of soil behind my house. Just this Saturday, I estimated it was 30 truckloads that came from Plainfield, New Jersey, from American Water site. It's continual. He did it today again, and he continues to dump. I'm in favor of the ordinance you're looking to pass. I think it's a great thing. The way you have it written, just a couple suggestions. The fine schedule, I can see this person taking advantage of the fine schedule you now have in there, which is $2,000 per day per dumping. I can see him consolidating his dumping to one day and putting 90 to 120 truckloads into that property in one day and eating the $2,000. My suggestion would be it would be $2,000 for the first truckload over 50 cubic yards, and then $2,000 again for any truckload you bring in after that. It's the only way that's going to stop something like this from dumping. It's continual. There's court case on, and he just keeps on dumping. He does not stop. One other thing about the ordinance, just for the legitimate companies in this town, there's farmers in town. There's other people that they have on their farms. They bring dirt in and they sell it. I think they should be exempt. Maybe the town could make a list of legitimate companies and let them bring soil in and then transfer it out, so they're not penalized by the ordinance. Because I know there's a lot of good legitimate companies in town, and if, say, the zoning officer made a list of them and allowed that list of people be exempt from the ordinance.
I think they do exempt people in it.
I read the ordinance today. I didn't see anything like that. One other thing is, if you do pass the ordinance, I didn't see anything in there about where the soil is coming from. Maybe if you have the ordinance and you state to them they can bring the soil in, you have to know where it's coming from, because it can be coming from anywhere. Those are my suggestions, and I do back the ordinance the way it's written. I wish it's passed as soon as possible. Maybe these could be amendments going forward. Thank you very much.
Thank you. And just for the council's notice, the zoning officer is here this evening, as is Corey Stoner. So when we do get to the ordinance, they'll be able to address any questions you may have with it.
Thank you.
Thank you.
Good evening, Jesse Palladini. Okay, interesting that you put that little Palladini versus Township of Vernon up there,
Please
but didn't
address
put
the
any
council.
of the other.
Please address the
Didn't
council.
put any of the other lawsuits against you, nor did you mention the ethics charges against the attorney and the mayor for violating the council's wishes to settle the matter.
Excuse
Okay.
me, Ms.
So I'm
Palladini.
here
There's
tonight.
no ethics charges. No charges have been filed against me or against the mayor.
Really?
So absolutely not. And honestly, your statement is almost defamation
No,
and
it's
slander.
not.
Yeah, it is, because it's
sure?
absolutely
Not
untrue.
gonna waste my
No,
time.
it's absolutely untrue.
Not going to waste my... Okay, if you say so.
I know so.
Oh, okay, I know so too. Anyway, so I'm not sure what kind of game you're playing tonight in tabling that ordinance, but I'm here to tell you that there is no provision in the law whatsoever for what you are trying to do with the Route 515 Board of Ed building. None whatsoever, not in the MLUL, not in the state historic preservation statutes, and not in the township code for historic preservation. And I discussed this matter with the Land Use Board attorney prior to the Land Use Board meeting of March 14th, and he apparently agreed as well, because the Land Use Board did not take any action on it, and they did not discuss it because there was no provision. So that's all I have to say about that. I do, however, have one other thing to say, and that is actually a question. We all know that the contract purchaser of the BOE building is Bruce Zaretsky, and we also know that the contract has language in it regarding the historic landmark designation of the building. So my question is to Councilwoman Jean Murphy. Ms. Murphy, have you ever listed, shown, or sold a property owned by Bruce Zaretsky?
This is not a question and answer, and when you're done, you can step down.
I didn't think you'd answer that question, but that's okay, because if you were in conflict, you voted on it on February 15th, and it's very easy to find out whether or not you are.
And again, I'll follow the attorney's lead. I am not in conflict, so if you're done, thank you very much.
I'm not done, but thank you. You are so rude,
Are you done?
Miss Huff and Puff. No, I'm not. Mr. Auberger, I'm sorry to say to you as well that you cannot discuss this or vote on it either whenever you put it back, despite having done so on February 15th. And that's based on the fact that as a member, trustee / officer of the Vernon Fire Department, your building is right next door and comes within 200 feet. Don't rely on your attorney's advice. Rely on case law. Grabowski versus Township of Montclair. And that's not the only case law. There's McAvee versus Board of Adjustment. There's Marlborough Manor versus Montclair Township. The court ruled that the long-standing conflict of interest rule applies when a public official serves in a substantive leadership role in an organization or that is the owner of property within 200 feet of the property in question. The public official should refrain from involvement in the matter. This includes public officials involved in religious institutions, community groups, and other organizations. When volunteer commitments conflict with land use matters, there is a simple solution, the court has ruled. That public official should refrain from involvement in the matter. So that tells me that neither Eugene Murphy nor John Orberger should be acting.
Thank you for your
on this
legal
matter.
opinion. Is there anyone else that would like to address the council?
You are possibly the rudest council person Vernon Township has ever known.
I highly doubt that. Thank you. Is there anyone else that has any question or would like to make any comments? Please step forward.
Sally Rinker, Vernon. I think you have on for introduction tonight Ordinance 18-14, Abandoned Properties, Unfit Buildings. That was formerly numbered 18-10 at the last council meeting. I have no real personal concern with this ordinance as a property owner. I don't believe any of my properties would fit this criteria, but my concern actually is just as a taxpayer. This ordinance was a 22-page document that caused such concern for the majority of the council that the majority of the council directed the clerk to arrange a public work session at the last meeting. A public work session is for the benefit of the public who are impacted by new laws, requirements, and fees, as well as the council who needs to work through the details prior to a vote to enact those laws. I don't know what happened to the work session. I thought that was going to be in between it being posted again on the agenda. And I wonder who decided to remove 16 pages of that 22-page document. Just like that, poof, 16 pages went away between the last meeting and this meeting, so now it's down to a 6-page document, which is a lot friendlier looking. However, there's still some problems with it. If you want to make lists of properties, fine. If you want to charge banks for not keeping proper care of properties, that's fine too. But I don't think we should expect taxpayers to foot the bill for rehabilitation and repairs of abandoned buildings. I think you're opening up a huge Pandora's box of legal issues and wasted money, to be honest with you. Ownership of these properties are a moving target. For instance, if you spend taxpayers' dollars this week on a property, the properties can change hands next week, as properties like these are often sold in bundles from bank to bank and investor to investor. They're packaged up and sold to who knows who. Sometimes we homeowners may not even know who owns our mortgage. It gets a little, obscure sometimes. So I believe you have a responsibility to Vernon taxpayers to not waste our money that we will never get back. So I would like to see a consideration to remove paragraph F under 130-7 under violations and penalties, which gives you, the administration, council, I'm not sure, you, the authority to use taxpayers' dollars to rehab abandoned and unfit buildings. I think it's a terrible idea, and I think it's destined to cause unwanted debt on the taxpayers. Thank you.
Is there anyone else that has any comments?
Larry McPhail. I live in the Sussex area of Vernon, and I had a lot more issues, but I since read the existing ordinances, most of my issues are with that and not with the proposed.
Which ordinance is that?
1809, the charitable solicitations. So I just want to address the one issue that I think is in the wording, which has to do with the written receipts for contributions as that pertains to roadway solicitation. Dollar or more from any contributor is undoable in a roadway solicitation. And I understand the receipt protection, but perhaps changing the wording from shall give in a roadway situation to may give on request. The IRS looks for $250 floor on cash contributions, and these are cash gifts more than anything else. Nobody's going to sit there in traffic looking for a dollar receipt. As I said, the other issues have to do with the already existing ordinance, so thank you.
Thank you. Is there anyone else that has any comments?
Hi, Lisa Anderson from Glenwood. I came tonight for the 1811 ordinance, but if it's tabled, does that mean it's going to come up another time?
Most likely.
It may or may not come up another time.
Well, I came out, so I might as well talk. I just would like the council to just consider two things if it does come back up. The first one is if it does go through, I really think it's going to set a really bad precedent. It's going to just allow every single historic designated property in Vernon to go away. So please just consider that. This one property you might be working on now, but it's going to have lasting effects. And the other thing I just wanted to bring up, and I said this to the Land Use Board meeting a couple of weeks ago, just think about this. There are other countries where, like, they take photographs and they doctor out people out of the photographs, and then they publish those doctored photographs in history books. And that's literally censoring history. So I think if you revoke this designation, you're literally erasing history. And, like, do we want to be the town that, like, censors history like that? Like, I wouldn't want to be the one that voted on that. So that's all I have to say. Please consider that. Thank you.
Thank you. Is there anyone else from the public that has any comments? Seeing no one else, may I have a motion to close to public?
Motion.
May I have a second?
Second.
All in favor?
Aye.
Any opposed? Next on the agenda, the item for discussion we have is the abandoned property ordinance. Oh, I'm sorry.
think we
Oh,
do
sorry,
minutes
I skipped the minutes. May I have a motion to adopt the minutes for February 26, 2018?
Motion.
May I have a second?
Second.
Roll call?
Yes.
Yes. Yes.
Yes.
Yes. Okay, now we'll go on to the item for discussion, which is ordinance 1810. Our attorney.
Oh, the abandoned property
Yeah,
ordinance?
the abandoned property.
Certainly. So the purpose of the abandoned property ordinance is, as most of the public is aware, since 2008 in the mortgage foreclosure crisis, properties that homeowners who could not pay their mortgages often left their properties, and the banks were not taking care of the properties. So what has occurred throughout the state of New Jersey is multiple municipalities have adopted ordinances similar to the one being proposed tonight, which requires abandoned properties, if they are not kept up, the township will create a roll. The properties will then be registered. There's a registration fee that's required to be paid by the banking institution or the owner. What ends up happening is that by charging back to the bank, whoever does own the property, you're getting their attention. Nothing gets a bank's attention like a bank getting fined. You're then creating additional revenues for the township. The way this ordinance is structured is that there's going to be an 80-20 split. 20% of the revenue collected by the ordinance is going to go to code enforcement. 80% is going to go back to the general budget. Regarding the comment about properties being bundled up and sold, properties are often bundled up and sold as part of a mortgage-backed security. But every time a mortgage-backed security is bought or sold, new documents are recorded and made part of the public record. So and I'm sure there are many homeowners in the audience tonight and homeowners watching on TV whose properties have been part of a mortgage-backed security that was bought and sold, there's a recorded document that shows who the prior owner of your mortgage was and who the current owner is. So I don't believe the township will have, and it's important that those documents are recorded, because if they're not recorded, the bank will lose its priority interest wherever it falls in the scheme on that piece of property. So the municipality will have a way through the recording system to always know who the owner is that they should be contacting if a property is abandoned, so that they can be assessed the appropriate fee. Regarding rehabilitation obligations, there's nothing in the ordinance that requires the township to rehabilitate or renovate any property. All the township is reserving for itself is the right and the ability to go renovate a property if it is necessary to do so. But it's certainly not compelled or required to do so under the text of the ordinance. So essentially what the ordinance is doing is it's creating a roll of abandoned properties within the township. It's requiring those properties to be registered. It's fining the banks for the condition of the properties and creating additional revenue for the municipality. The municipalities that have enacted these ordinances have reported back to the township that they have realized much needed revenue from the ordinances, and there has not been a negative effect after being enacted.
One of the items I wanted to just bring up is, and I'm not sure if she's prepared to speak about it, our zoning officer, Allison LaRocca, was involved in the one building at Northwoods. Is it appropriate that she speak about that?
I mean, if Allison cares to speak about what the condition of Northwoods is and how the ordinance would impact Northwoods, that would be fine. I'd rather she not speak about any litigated matters with Northwoods.
Has it been, but it's been litigated?
That's fine then. If it's been concluded, that's fine.
It's, okay. They still have
Okay.
20 days. Okay. Okay. So if she has,
It's probably better that she does not talk about it.
but that is a building that the mayor did bring up that is between the Appalachian Hotel and the old medical building, which is by Cumulus. If you look deep into the woods, it's actually a section of condos that has been sitting there vacant for years. As a matter of fact, it took several years for them to determine, I guess the owners to determine which owner actually owned it. But it is a dilapidated building, just happens to be that you cannot see it. A couple other properties that are across the street from Great Gorge Village, where the riding stables are. If you look behind there, there's patio homes. They've sat back there in shells, vacant for, well, probably well over 20, 25 years. It's to address properties like that, as well as homes that are owned by banks that let them sit. Now, when we have our neighboring town like Wantage, who has an ordinance like this in effect, and a bank is dealing with properties, yes, they're going to try to move them here, but they're also going to be concentrating, in my opinion, on the municipalities that are enforcing laws where it will cost them. And I did ask our business administrator, when he said that Wantage did have, I asked him, I said, could you please find out how are they doing? Because they've been, I think they started this in 2016. So in 2017, they registered 149 vacant properties. And I think what they came back and the administrator said that it was $200,000, about approximately $200,000 that they were able to collect in fines and fees for these vacant properties. It's really to help everybody move along. If any of you live next door to an abandoned house, you feel the pain. The people that do not may not understand it.
I think it's a townwide issue because as abandoned properties are not taken care of, it depresses property values throughout the town.
So do any council members have any questions of the attorney?
I'm kind of curious as to a chronological breakdown of the effect of an abandoned house on the taxes and the reserve for uncollected taxes. Is there an attempt to reassess when it's abandoned?
I don't believe there's any attempt to reassess, but what will happen is a bank, knowing that most municipal liens will jump it in priority, a bank will pay the taxes in order to ensure that it maintains its first priority lien status. Usually that's what happens. Now, in the case of where you have a property that's not owned by a bank, where you have a individual owning the property. If that individual can't maintain the tax payments, then they won't, but then the tax lien can be sold and then the property can be foreclosed upon.
Is there a period, is there a period where an abandoned property is, for instance, Gene just mentioned 20 years, that it simply can be bulldozed and torn down?
There are probably processes and procedures whereby you could declare the property unsafe, but ultimately you're not going to be able to take the land from the landowner.
Right. But is there a clause in here that...
The primary purpose of this clause is to create a roll of properties that meet the criteria for being abandoned, to find the owners, to get their attention so that they will begin to repair and rehabilitate the property. Certainly the zoning officer, there are other provisions of the zoning code that would permit the zoning officer to fine the property owner for failing to upkeep the building. And depending on whether those go to judgment, whether or not the judgment's paid, the municipality may acquire a judgment lien and then ultimately be able to enforce it. This ordinance does not give the township the ability to take a property from somebody for being abandoned.
Right. But the former one did, I take it.
It may have. The former one was certainly a more aggressive abandoned property ordinance. That ordinance had received municipal awards for helping eliminate the blight of abandoned properties in inner city or in and around Newark. But this is a gentler ordinance, I would say.
And you've done what I commented on, and that is to simplify it. That's done.
The Rehabilitation and Abandoned Property Act.
Louder.
The Rehabilitation Act, or Abandoned Property Act, you can take the house away, am I correct?
Which statute are you referring to?
On F here.
On F?
Yep.
Section 1.
Well, this is
So to enforce that, I believe, does it say in that act you can take the home away?
I don't know. I would have to look at the statute, but I doubt that the statute allows a municipality to take property without compensation being paid. That would probably violate the takings clause of the U.S. and New Jersey constitutions. But again, all the municipality is doing in subpart F is reserving for itself those statutory rights that are granted to it. It's not compelling them to do it.
Right, I understand that. Again, I'd like to see F removed, because this, if you decide to enact on this, and I don't know if you guys read this whole thing, this would require a whole department to take care of this. It's going to be a lot of work if you're going to start inventorying all these homes and deciding which ones are abandoned and which ones you're going to be fining. Even that alone is going to be a lot of work. So my suggestion is to remove F for possibly maybe later down the road, see where this takes us. But I don't think this town is in a position to start rehabilitating homes. And because it's there, we could act on it.
On the other hand, there may be grants that come available with the new administration.
You know, I believe it will take a whole department. Read that act. It's a lot to it. And a lot of that verbiage, which was in the old ordinance was written, came from that act.
Again, all subpart F is doing is granting to the township the rights that are the legislator granted to it under the Abandoned Properties and Urban Redevelopment Acts. Nothing is compelling the township to do anything in subpart F.
You know, that is my suggestion.
I mean, I'd have to say I'm not in favor of the township purchasing or taking any property. My opinion of that is it's taken us this long to try to dispose of the Faline building. I couldn't imagine what would happen if we took over a house. But in the meantime, with this ordinance, the spring is coming. And a lot of people don't see it now with the snow that we still have on our lawns. But the minute the sun comes out and the yards dry up, the lawns are going to start growing and the phone calls are going to start coming in, and they're going to be going right to the zoning officer. And they'll be going out and they'll be patrolling, and there will not be much that they can do. I mean, they can sit and monitor the grass, but like I said, I have absolutely no issues with it, other than I'm not in favor of the township purchasing any property, and
What would be the end?
Rehabbing.
What would be the end result if
the statute's
property?
enacted right, nothing in the ordinance requires the township to buy or rehabilitate anything. It is a process whereby the township can assess a fee against a property that's determined to be abandoned. I'm not aware of any municipality in the state of New Jersey that's enacted such an ordinance that has lost money on it. Every municipality that's enacted this ordinance that I'm aware of has made money on it.
And I've seen many that have included this word for word from a lot of towns, word for word, but do not include F in it. I strongly suggest removing F for now.
That's
I'm
a
sorry,
policy
what happened?
decision for the council to
Pardon
make.
me?
It's a policy decision for the council to make, whether they want to
Removing F.
take for themselves the rights granted by the state legislature or not.
Removing F does not interfere with any of the fines or fees.
Not that I'm aware of.
Councilmember Kadesh? 'Cause I know that was something that you... That was something that you wanted. Well, it was something that you had brought up.
I still feel you should leave the possibility open. Like I say, there could be new grants coming from the state or the feds. I personally did a lot of development in Hoboken and in Jersey City that had HUD grants that made the kind of investment in a dilapidated building very, very possible. It's a common instrument that you use to improve an area that needs it. I just don't think you should. I don't think it's a matter that's very important at this point. You take it out and you
can add it later
truncate
on.
any possibility.
You could add it later on.
Depends on the council.
I mean, did you read this act, what this all entails?
Yes.
You're going to have another department to enact this. And then which houses are you going to choose to rehab? She's got to make an inventory of the list. Is it going to just be in redevelopment area? Is it just going to be residential area? I see a lot of problems with this. There's going to be a lot of problems. That's my perception. You're going to have to hire more employees if you're going to enact on this.
Can we take a vote on whether to remove F from this and proceed?
Sure. We have to do a roll call. We wanted to.
I'll make a motion that we take F out.
What was that, Mr. Allberger?
You'd like to
I make a motion to
remove
take F out of the
Second.
town having the ability to rehab.
I second it.
Roll
Maybe
call.
in the future, but I don't think we're in a position right now to do this.
Roll call.
Councilmember Owens?
Yes, minus F.
Councilmember Kadesh?
No.
Councilmember Van Tassel?
Yes.
Councilmember Allberger?
Yes.
Council President Murphy?
Yes.
Motion carries to remove paragraph F. Draft.
So, Laura, when it gets introduced, it's introduced without F.
For introduction tonight, if the council would like to introduce it.
Correct.
May I have a motion to introduce ordinance 1810?
Motion.
18,
Oh, I'm sorry.
14.
Oh, sorry. Put my glasses on.
There's a motion by Councilmember Van Tassel. Is there a second?
I'll second.
Councilmember Owens? Councilmember Owens?
Yes.
Councilmember Kadesh?
Yes.
Councilmember Van Tassel?
Yes.
Councilmember Allberger?
Yes.
Council President Murphy?
Yes.
Motion carries to introduce ordinance 1814 without paragraph F, with a public hearing to be held on April 9th.
Okay, we'll move on to the consent agenda. Administration has asked us to remove Resolution 18111.
Yes, and I have a question. Could you pull out 18-117?
Sure. Resolution 18110, this authorizes tax premiums to be returned to the township. Resolution 18112, this resolution authorizes new copiers for the municipal building as we are at the end of our current contract. Resolution 18113 This resolution provides for reimbursement for retirees for the State Health Benefits Plan. Resolution 18114, this authorizes the health insurance benefit waivers for the year 2018. Resolution 18115, this authorizes a change order for firefighter apparatus. Resolution 18116, this authorizes the township to use certain co-op vendors. May I have a motion?
18110 and 1812 through 186.
Yep. Yep. So may I have a motion to adopt Resolution 18110, 18112 through 18116?
Motion.
May I have a second?
Second.
Roll call?
Councilmember Owens?
Yes.
Councilmember Kadesh?
Yes.
Councilmember Van Tassel?
Yes.
Councilmember Alberger?
Abstain on 115, yes to the rest.
Councilmember Murphy?
A resolution,
I'm sorry, I didn't hear you vote.
I said yes. Resolution 18117. This authorizes balance transfers.
So my question, and this is probably for Ms. Jetter, taking the resolution title is from fund balance transfer, but these are coming from line items in the 2017 budget.
Yes, it's not coming from the fund.
It's not coming from the fund balance.
No, it's coming from the items
All right,
on the
because
left.
that was a little confusing there when it says that. Okay,
Yeah, I just took the prior year and
okay, that's good. Okay, that was my question. Okay, I'm ready for a vote.
May I have a motion to introduce Resolution 18117?
Motion.
Second.
Second. Roll call?
Councilmember Owens?
Yes.
Councilmember Kadesh?
Yes.
Councilmember Van Tassel?
Yes.
Councilmember Alberger?
Yes.
Council President Murphy?
Yes.
Motion carries to introduce 18117. Or
Ex-
adopt.
Yeah. Introduction, first reading of proposed ordinances, Ordinance 1812. This ordinance to amend and supplement Chapter 89 of the Code of the Township of Vernon entitled Personnel Policies. This establishes a health insurance waiver program for the township. May I have a motion to introduce Ordinance 1812 with a public hearing to be held April 9th, 2018?
Motion.
May I have a second?
A second.
Roll call?
Councilmember Owens?
Yes.
Councilmember Kadesh?
Yes.
Councilmember Van Tassel?
Yes.
Councilmember Alberger?
Yes.
Council President Murphy?
Yes.
Motion carries to introduce ordinance 1812 with public hearing on April 9th.
Ordinance 1813, an ordinance of the Township of Vernon in the County of Sussex, New Jersey, authorizing the purchase of various equipment and repairs in, by, and for the township pursuant to NJSA 40:56-1 and appropriating therefore the sum of $15,750 and providing that such sum so appropriated shall be raised from the Capital Improvement Fund account of the township. This is a capital ordinance for 3 small items, and the township is purchasing directly. Mower head, freezer for the senior center, and lights. These items will not be bonded. May I have a motion to introduce Ordinance 1813 with a public hearing to be held April 9th, 2018?
Motion.
May I have a second?
Second.
Roll call?
I have a question before we roll call. May I ask it?
Sure.
Ms. Shatter, just a question. Is that coming out of the 17 budget for all those items? I know we discussed those items at the budget meeting.
these are coming out of the 18 capital improvement
Okay.
fund. And there's some remainder from the capital improvement fund from
7.
last year.
Okay. Okay.
Roll call?
Councilmember Owens?
Yes.
Councilmember Kadesh?
Yes.
Councilmember Van Tassel?
Yes.
Councilmember Alberger?
Yes.
Council President Murphy?
Yes.
Motion carries to introduce ordinance 1813 with a public hearing on April 9th.
We did that. Ordinance 1850, an ordinance of the Township of Vernon, County of Sussex, State of New Jersey, creating Chapter 484 of the Municipal Code of the Township of Vernon entitled Soil Fill Placement and amending Chapter 250 of the Code of the Municipal Code of the Township of Vernon to include soil fill permit fees and escrow. This places limits on the amount of soil placed on a person's property as well as a procedure and enforcement mechanism if those limits are exceeded.
You want to open for discussion?
Well, prior to this, whether or not, I think maybe if we could have our engineer, Corey Stoner. we have a discussion on this?
Can I take a seat here for a second?
Oh, sure.
Okay. Everyone, this ordinance is a ordinance to control the unregulated and uncontrolled placement of fill within the township. As a township, there's some concerns about small and large operations where there are fills being placed and it is not regulated. It's not regulated by soil conservation or any of the other ordinances that exist today. And the idea is to determine how the soil is being placed on the property, how it's being, it's not going to impact any environmental and sensitive areas. It's not what impact it has on neighbors, what impact it has on our roadway system. These are all items that just are not being addressed under our current code. So this ordinance will establish Chapter 484, which we're calling the Soil Fill Ordinance of Vernon Township. The way it is established is we broke it. When I say we, I worked with the zoning officer and others in the town hall here, including the business administrator and the mayor, regarding what type of applications to control. We came up with the option of having a minor soil fill permit and a major soil fill permit, which would regulate, minor soil fill permit would regulate small projects up to 500 cubic yards of fill, and anything over 500 cubic yards of fill would require a special soil permit from the land use board. It would trigger land use board review application review. The application, the way this ordinance is set up, we set up the different soil permits. We had initially 50 cubic yards to 500 cubic yards being a minor soil permit, and anything over 500 being a major. Excuse me?
Is this new one say 100?
No, well, I'm just going to correct myself on that. Originally, I had stated 50. The last few days, especially today, I've had some conversations with some contractors and some other representative people within the municipality, and in the version that you have in front of you, we increased that to 100 cubic yards because we thought we were being too stringent on 50 cubic yards. A typical tandem truck will have between a tandem or a triaxle between 50 to 20 tons of truck. So if we are 50 cubic yards, that's only 2 or 3 truckloads of material. And the concern was that if we made it that lenient, or that strict, that we would be prohibiting some landscaping operations and minor operations requiring property owners to come in for a permit where it's really shouldn't be a big deal, okay? So we increased, in the ordinance that you have in front of you, it was increased at 100 cubic yards to 500 cubic yards would be a minor permit, which a minor permit would include a permit application to the zoning officer. Zoning officer would review the application, determine what impacts it does have on the surrounding areas, the property itself, if it's not triggering any kind of stormwater concerns, soil erosion concerns, environmental buffer impacts, and the like. And there is also a provision if it gets too technical in nature that I can be brought into the application review with an escrow account. And that's only if the zoning officer is not comfortable making a determination on her own. Anything over 500 cubic yards would go directly to the land use board. 500 cubic yards, you are talking you're getting into a larger scale project up to about 30 loads of soil. This is a type of project we thought that would be beneficial to be brought to a land use board where notice would be provided. The property owners would all have a chance of talking, ask questions, and comment on it, just like any other land use board application that we see today. Okay. We have a number of exceptions and exemptions in this ordinance. I heard another one this evening. I did not think about that. Maybe we can add something more in for agricultural uses, farming operations. But the current version that you have in front of you has about 5 different exceptions. One is any project that includes the excavation or backfilling around a building foundation, septic system, or sewer lines, they're exempt. as long as they have another building permit, like a construction permit, a zoning permit, a lot development permit. We're not trying to make people come in for two different permits. We don't want them coming in, because those projects are being watched underneath another form of regulation. We're not trying to over-regulate and have people come in for multiple applications. Just this is more for an application that does not have any review. Other exceptions would be anything that falls under a land development application already, a site plan or a subdivision, because they're already being reviewed by the board. We have a provision in there if it's a state mandated cleanup, approved soil removal project. And I added one today, which regarding if it's not, shall not apply to the storage of sand, soil, stone, topsoil, mulch, or other materials on lawfully existing landscaping or contractor yards. Two of the contractors I spoke to today, I was trying to get a feel for the local feel for contractors on properties, and they gave me some good information. In fact, they were concerned that if they took fill from a septic system they were constructed and they temporarily stored it on their yard, they're not filling. They're not filling for the purpose of filling. They're putting it in the yard as temporary storage to use it on another project. So I took that out made that an exception, as long as it's lawfully existing. Thought that was important because I want to make sure you have a permitted use. As long as it's permitted, either a permitted use or it's an existing non-conforming facility, I didn't want to cause another violation by accepting that out. We do have, through the ordinance, we have provisions of means of how the application is supposed to be submitted and what the reviewers, which would be the zoning officer, myself, as well as the zoning land use board. We do have under a major soil fill that does list the source of material. That was a question that was come up today. It's not specifically listed under minor, but that can be added to the minor portion of this application as well. The biggest part of it, we want to know where it's coming from, where it's being placed, how long the fill operation is going to take, and the proper and is it causing any issues onto a neighboring property or our infrastructure. One of the concerns is our infrastructure. If you start getting truckloads and truckloads and truckloads of material on our roadway system, either municipal roads or private roads, because we have a lot of lake communities, roadways that aren't ours, that they're not constructed. A lot of these are not constructed with our same construction bed that a lot of the municipally owned roadways are. We put provisions in here for how the permits will be issued, restoration, and I do have an enforcement in here, which the way I wrote it was, I believe I took this from your example that your Josh had provided me from another town, and you can correct me wrong. The way I wrote this up was that it's a maximum fine of $2,000 or imprisonment for a period not to exceed 90 days or both. Each and every day such violation continues or exists shall be considered a separate and specific violation of the provisions and not a continued offense. So the way I was interpreting that it was $2,000 a day, not $2,000 period.
Yeah, that's what I interpreted. It was $2,000
Because the important line was the line that stated each and every day continues or exists shall be considered a separate offense.
That's $2,000 a day.
$2,000 a day. Okay. I was playing legal attorney, and that's not always good for an engineer. So thank you, Joe. The corrections, like I stated, the things that we made changes were we upped the minor soil permit to 100. The definition of soil, I did do a different definition. There was a question that was brought up. There, contractor was concerned that the bringing in a quarry process or rock product for the construction of a driveway or a roadway would be considered fill, and that's not the interpretation. I changed the definition of soil to include dirt, stone, gravel, sand, humus, clay, loam, and mixtures of these, but this shall not include quarry process or rock products utilized in construction of roads, driveways, or similar types of construction. Didn't want to, somebody's building a driveway and they have to bring 8 loads of DGA in for the driveway reconstruction. That's not what the intent of the fill was. The fill ordinance was bringing soil in, unregulated soil from a site we don't know where it's coming from and how it's being placed. It's not to construct a driveway or a septic system or a house foundation. That is not the intent of this. The intent is just mass filling. We have had a couple of situations in the municipality. We have a large one at the moment, which would definitely fall into this, which would require land use board approval. We also have, I've seen a number of these situations in the lake communities where they put fill in and they change the direction of stormwater. Where at one time it used to go to the north and now it's being pushed to the east because they filled and they changed the drainage pattern. And they've come to the municipality, they've come to me asking for what can we do for drainage, and there's nothing I could do. It really became a civil issue, but it wasn't something that the municipality had any jurisdiction over. So that's the backing to this ordinance. And then the fill, the 100 cubic yards seem to be in my mind, a good line, a good amount to start with, because I'm considering an ordinance for the whole municipality, not just one area. There's some properties where 100 cubic yards will make no difference on what's a very large lots, but you have a lot of lake communities where 100 cubic yards will make a big difference on the drainage patterns and the fill on a property. So I kept that at 100. 50 was from another town. I was looking at their ordinances and got some guidance on, from some of my colleagues what they were using, but it seems to be too small for Vernon, so I moved it to 100.
Question I have on the escrow, 500 per job, let's say on the minor fill. If a contractor has, 6 jobs going on, they have to provide escrow for each one?
Depends on the project. The project itself is, if they're constructing a house, they're constructing a septic system, they're constructing a driveway project, and they're not bringing that fill in, it's not going to trigger this. But if they have 5 projects where they're dumping more than 100 yards of fill for bringing up the grade of a yard, or they're increasing the width of their driveway, if they're bringing that much material in, yes, it would trigger it. And the way it's set up is the $100 fee. I believe some of your fees in town, the way I set it up was basically how many. I figured I'd take your zoning officer a few hours to review this application. They're going to bring it in. They're going to go out and look at the site. They're going to do the application. Before you know, there's 2 to 3 hours. That's how I established 100. And the 500 escrows, if they need it, is my time. And if I'm not needed, then it will be returned right to the applicant.
And I had a conversation with Allison today. These fees, they're not just for contractors. It's for a homeowner. If a homeowner is having dirt delivered, does the homeowner would a homeowner at some point be responsible of getting the permit and not the contractor?
Well, it depends on their contract. Obviously, the contractor might be in charge of the whole thing and might be putting the application together for the homeowner. That's common on any application, but normally it's the homeowner does it because they have to sign as the owner.
So then could the escrow be coming from the owner?
Everything, it normally comes at
That's
one
what I'm saying
time.
is because it was a contractor question today, if they had X number of jobs going on, but when in fact they could be getting the permit, but they could also have the owner getting the permit. That's what you're saying.
Or they build it into their cost. I understand it could. This really started out with some of the major projects is what our biggest concern is. But as we're writing this up, we're trying to write it up for the full municipality, so you have an ordinance that it can be enforceable everywhere in this town. And I personally feel that the minor should stay in. Some of the contractors one of the contractors was asking if we could just remove the minor in total. You could do that, but I don't recommend it. I have some concerns. If somebody brings 400 cubic yards of soil into a quarter-acre lot, that's a heck of a lot of soil. But it would not be regulated at all by this council. So that was my thought process behind it.
Any council members have any questions?
And would it be prudent or possible, or what is your recommendation, to have a clause that we reserve the right to test the soil? I mean, if we're looking at contaminated soil, there might be an instance where we would want to test it. We don't know where it's coming from or it looks suspicious. I mean, is somebody going to go out and look at these piles of dirt you get delivered? You're going to get your permit, but is somebody going to actually go out and view it?
Well, it's a good question.
You know, it's
I do have the
sentence.
source, we can write in there the source of the soil, it's a question about the soil itself. We can write some provision in there that the soil,
Call for certification of the source?
I did not, because most of the times you don't get a soil certification. Let me give you an example. If you have I think a lot of issues are, the ones I was hearing today, especially if you have a contractor who is putting a septic system in, a brand-new septic system, virgin ground. They take the soil off that site and being moved, and it'll go to another site. I believe it'll be, you could require that, but I think it'll be a hardship on local small contractors to do that operation. You can give they can give a certification of their certification where it's coming from, or a certification from the owner of the property where it came from. Like if they get it from block and lot on the other side of town, they can get a certification from that property owner that states that yes, it came from my property.
No, it's rumored some of the soil that's coming in came from a gas station.
From one of the issues in town, yes.
When-
That owner would have to provide a certification where it came from.
Well, but we have that in the ordinance.
I have, as part of their review, and I have this for major project, the application that they submit will have to provide the source and material to be used as fill. I do not have it written in there as certification. That could be added to it.
And that's for the major?
That's for the major, but the comment today, it wouldn't be a bad thing if I can add that in for the minor as well.
Can we
Source,
write it in
the
as
source and certification.
the town has the option to require it?
Well, I don't know about that. I mean, you're saying have it pick and choose?
Randomly?
Yeah.
No, the point is, if it's well known that the soil is coming from a recognizably safe source, is there a need for certification? But if it's rumored or seen that it's coming from a source that may be contaminated, we should have a way to deal with that.
I believe if they're telling you where the source and material is coming from a certification, there is, I think the question was whether or not we check on it later. We do check and see if, their operation and if they do what they're supposed to do, during the operation, that they actually constructed. If there's any kind of question, we can turn that into a DEP, violation, turn it over to the DEP. I don't know if the town has a jurisdiction over to determine if a soil is contaminated or not. I think that goes to the State Department of Environmental Protection.
But in the permit, can it be a required swearing to the source is safe, and with possible fines if it's not?
But how's a homeowner going to know what's the soil is safe?
They're not. They're just going to say it came from their.
It's dirt broker.
You're taking it from Storm King, obviously. You need to have some certification.
Yeah, is this supposed to address the placement of the soil or the actual soil content itself? I mean, this seems to revolve around the placement of it. Nothing really addresses the soil itself. I mean, there's a lot of dirt brokers that sell contaminated soil. So,
How expensive is it to test the soil?
Could be a couple $100.
Or 1,000.
It could be more.
and how do you assure you're getting clean fill?
Yeah.
Yeah, I guess the issue is right now we have no means to even get them in the door. I thought, in my mind, it was if we get them in the door, we know what source it's coming from. They're giving us certification. I can add in there that they give us certification that the material is clean and meets certain statute. I can put a statute of being clean fill. I can add that in here because there's New Jersey statutes of what clean fill consists of. I can add that there. There's certification thereof. And if we have a question, we can put language in the violation. I believe in the back, we can add something in here that states that that the fill has to be clean fill.
Yeah, if that's what you want to address, I'm just throwing that out there.
The violation would be based on the fact that they're not complying with their application, their permit, which their permit would be the placement, but also the fact that it's clean fill. So I can add a definite, a section in here for fill to be considered clean fill according to NJSA, NJAC, whatever. There's a statute.
You could probably also provide the permit that when they fill out the permit and get it, that they sign and certify that all fill to be placed pursuant to the permit is clean and meets statutory requirements.
The comment there was as the permit application that
On the permit, when the person picks up the permit, have them sign on the permit that they certify under the penalty of perjury that it's clean soil and it meets statutory requirements of clean soil. So therefore, when they get the permit, they have to swear that this is clean.
But is that possible? I mean, is that going to be unreasonable? I don't know. I've never bought dirt. So, I mean, if I was a homeowner and a contractor was bringing me dirt and I fill out a permit, I don't think I can swear that it's clean fill.
Well, you would. Well, you're putting the onus on the homeowner to do the investigation. That whoever they're using is providing them with clean fill. As Corey indicated, there's state statutes that regulate this. There's criminal penalties that flow from dumping dirty soil.
So if you bought fill from somebody and you said, "Is this a clean fill and it's not contaminated?" and then say yes, then.
Well, if they dupe, no, you wouldn't let the homeowner off the hook. The homeowner's recourse would be against the dirt broker that lied to them, rather than the township letting the homeowner off the hook.
I think there's fill on that property, and the homeowner received it. They have
Statutory obligation.
And it'll be their responsibility to remove it. Right?
It's not all on the contractor. Well, it is. I'm sure they're going to go back to the contractor, but it's got to be on the homeowner to make sure that they have clean fill on their property.
Where does soil conservation come in?
Soil conservation is anything over 5,000 square yards of soil disturbance. Soil conservation will come in, and really, what you're going to find is that for anything in the minor permit may not trigger that 5,000 square yards. It's likely once you get over into that major permit, it's going to trigger a soil conservation permit as well, which. That just means Sussex County Soil Conservation will become involved. Our concern is when it's in a minor permit, it's a good chance it's under 5,000 square yards, and it's not going to be regulated by Soil Conservation either. We have, we've talked about some situations in town which are over 5,000 square yards. The Sussex County Soil Conservation District has become involved, but they're restricted on what they can go do as well. Our ordinance is hopefully to give a little bit more teeth to go under the unregulated fill sites.
So right now you're looking at adding the agriculture?
I was going to add language to exempt farming operations, add a section on state statute regarding clean fill, and the source of material to be used and to be noted on the application, along with a certification that the soil meets that statute, the clean fill statute.
And while you're still here, if I might ask if the zoning officer, if Allison LaRocca has anything to add?
I think Corey handled it. I think, we're just trying to be fair to the contractors, but we're also trying to stop what's going on in many different parts of our town. And like Corey was saying, I have somebody in Highland Lakes right now. They brought in so much fill that he raised his property 3 feet and is flooding his neighbors. And there's nothing I can do. Nothing I can do. I have people calling me saying our homes are being flooded.
I think that's
I raised his property 3 feet up.
I think that's a situation where they were under 5,000 square yards. So Sussex County
Nobody regulated anything. This guy just had the trucks come in, dumped it, spread it, it's good to go.
So, would you like to proceed with the introduction with these changes that Corey's?
You want to introduce it?
Do you want to proceed with the introduction?
With these changes.
With adding these changes to it?
Have the changes by the second reading.
Mm-hmm.
I'm good with that.
Is there a motion?
I'll make a motion.
Second.
So, do you have the correct language as to what Corey's adding?
I marked down, he said he's going to include the agricultural language, the clean fill, and the materials. I'm sure he'll have to give me the formal text.
Yes, I will.
And question to the attorney was, do we want to refer this ordinance to the land use board prior to adoption?
I don't think you need to.
I have a motion and a second to introduce ordinance 1815, the language corrections on Mr. Stoner to be forthcoming. May I proceed with the roll call, Councilman?
Yep, roll call.
Councilmember Ooms?
Yes.
Councilmember Kadesh?
Yes.
Councilmember Van Tassel?
Yes.
Councilmember Allberger?
Yes.
Council President?
Yes.
Carries to introduce ordinance 1815 with a public hearing to be held on April 9th.
Thank you. Corey?